First up, we're in Ann Arbor, Michigan for a motion hearing. 39-year-old Michael Young, who pled guilty to failure to stop causing serious impairment, has been sentenced to 40 days in jail and 18 months probation. 3.5 years earlier, according to police, Young drove his truck off the road through a ditch and into a car that was parked in a driveway. Inside the car was 76-year-old Patricia Vital. She'd been visiting one of her daughters when the accident occurred. Young called a friend for a ride and fled the scene before police arrived. Patricia was taken to a nearby hospital, but died from her injuries the next day. With the help of eyewitness accounts, police identified Young as the driver and he was arrested. One witness claimed to have smelled alcohol in his breath, but Young declined to speak to police. And since too much time had passed since the accident, his blood was never tested for alcohol. Young was originally charged with failure to stop when at fault resulting in death and failure to stop causing serious impairment. But the first charge was dropped when he agreed to plead guilty to the second. Today, Young appears before Judge Patrick Conlon, having only served half of his 40 days in jail. But because he's scheduled for shoulder, neck, and leg surgeries, which could require a lengthy recovery time, Young is asking the court to adjust his sentence.
You're asking for early discharge. You're still kind of on the hook to serve 20 days in jail. So one possibility may be that if we were to waive this requirement that you serve the 20 days in jail, I would actually extend your probation and you would be on a scram and a GPS tether.
But the judge is troubled by reports from the victim's family that since the accident, Young has been spotted at the local bar while on probation.
Can I comment on that?
Sure.
There's a restaurant. It's the only one. I don't know if you've ever been to Bridgewater. It's a tiny little town with...
I do understand that, but just remember, sir, we're here today because of the death of a family.
I understand. That's the only place around to go to lunch. There's nothing to do with drinking, and I understand. I mean, I feel for everybody here, and I don't know where else to go.
You're asking for early discharge from probation. I'm willing to extend your probation and waive one of the requirements of probation that you serve another 20 days in jail.
The prosecutor, Jessica Blanche, is not on board with this solution.
But there are victims who have lost a family member in this
For
case.
sure.
They were under the impression he was sentenced to a particular sentence. He was to serve this amount of time. For them, there's this closure here, and now we're saying, well, let's be accommodating. He's going to the tavern, and I get it. Oh, well, there's not enough places to be right. Well, you can get takeout. I mean, this is a serious offense where someone lost their life.
Like, you're 100% right, but is him serving 20 days in jail better guarantee that he's not going to hurt anyone else than extending his probation further with conditions to show that he's sober?
Can I say?
Not really, sir. After I hear from the victims, I'm either going to give you a choice or not.
Before Judge Conlon makes his ruling, Patricia's daughters address the court.
He got sentenced to 40 days. 40 days. I've lived every day of my life being forced to relive that night because he killed my mother in my front yard in front of my children. He didn't even stay until help arrived. He chose to run away. It feels like an insult to my mother's life and to my family.
I agree with my sister that 40 days, it is an insult. Yes, I know she was 76 years old and she was older, but she had a lot of life left to live. The sentence, in my opinion, was so lenient to begin with, and to be discharged early, it's just insulting.
After hearing their statements, the judge makes his decision.
In light of what the victims have brought to me, I'm not going to make any changes to your probation condition, and I'm not going to grant you early discharge. But I'm going to deny the motion.
Young remains on probation and still must serve the remaining 20 days of his jail sentence. Next, we're in Detroit, Michigan for a pretrial conference. 26-year-old Micah Bradford has been charged with 3 counts of assault in 2 different cases. She pled not guilty to all 3 counts, posted a $5,000 bond, and was released. Today, she appears before Judge Elenice Bryant to discuss next steps in the case. As the hearing begins, Bradford experiences some technical difficulties.
Judge, it looks like her device is not connecting.
But Judge Bryant is more concerned with another matter.
All right, I'm gonna. Miss Stevenson, you spoke to Miss Bradford in the breakout room, and now she's laying in the bed, attending court. That's so unacceptable and so ridiculous. I don't even know what to say. That's so unacceptable and ridiculous. I'm sending her back to the breakout room.
The judge moves on to other cases until the defendant finds a different location. A few minutes later, Judge Bryant recalls Bradford's case. This time, the defendant appears standing at a kitchen counter.
How are we proceeding?
Your Honor, on behalf of Ms. Bradford, we would first offer the court an apology for Ms. Bradford's prior appearance without offering this as an excuse. Just wants the court to know she was not lying in bed. She was on her bed trying to charge her phone. That won't happen again. She'll charge her phone.
She was laying in the bed. I don't care what she was doing in the bed. She was clearly laying in the bed. She could have charged her phone and not be lying in the bed. Second of all, once the court brought to her attention that she was lying in the bed, everybody else that was uninformed enough to come to court in the bed would get up out of the bed when the judge says, you're in the bed.
Bradford does not seem to appreciate the judge's comments.
Continue, Ms. Stevenson, but she was laying in the bed. Laying in the bed. She was laying down in a bed. Ma'am, anything you say probably is not going to work out good for you. Ms. Stevenson?
Thank you, Your Honor. So, Ms. Bradford, ma'am, if you could just listen attentively to what the court's saying. On behalf of Ms. Bradford, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Yes, Judge. So the people respectfully request the court to adjourn both cases for pretrial conference to give the complainant witnesses one more opportunity to appear.
The court is going to deny defense counsel's motion for dismissal. The court will set the pretrial conference for Wednesday, June 14th.
Before the hearing ends, the judge has a few more words for Bradford.
Ms. Bradford is having extreme difficulty in attending court properly.
And with that, the court completes one of the most significant sentencing hearings in recent memory. Beyond the life sentences, the restitution orders, supervision terms, and no contact provisions ensure that accountability extends far beyond today's hearing. What part of the judge's remarks stood out to you the most? The focus on public safety, the victim impact statements, or the sheer scale of the sentence?